All right. Mr. Jaffe. All right, this is the, are you here on Van Maren versus Davidson?
Yes, Your Honor.
Or next.
Jasmine Davidson is my client, Your
Or
Honor.
next. What's that? So
Yes,
I
Your
see
Honor.
Miss Davidson's here. And do I see Edward Van Maren?
Present in the courtroom, Your Honor.
All right, Edward Van Maren is present in the courtroom. So I have a motion for, sir, if you want to come on up, you can have a seat at this table. Oh, actually, you're going to be at that table over there, okay? All right, so I have a motion up for summary disposition. I've reviewed the motion. I've reviewed all of the documents that were submitted to the court. And is there anything that I need to be aware of?
Yes, Your Honor.
Your Honor, excuse me.
Wait, one
One
sec. Can I get your appearance, sir? Can you tell me your name?
Edward Van Maren.
Okay, you can have a seat. Mr. Jaffe, give me your name.
Your Honor, good morning. Attorney Brent Jaffe on behalf of Jasmine Davidson. Your Honor, if I could address the court with regards to the motion that I filed. Your Honor.
Here's where it gets interesting. Mr. Jaffe has filed a motion for summary disposition, which in plain English means he's asking the court to dismiss the case before it even begins because the plaintiff hasn't provided a legal claim that can actually be granted. Think of it like a technical knockout in court. The law doesn't bend for feelings or unpaid grudges. If you're watching and wondering why this is happening so fast, it's because the plaintiff didn't file a response. That's a huge mistake. If you show up unprepared, the judge can literally throw your case out without a second thought. Who do you think is at fault here?
Okay, so it's his motion for summary disposition. So Mr. Jaffe's going to go first, and then I'm going to hear your response, okay? All right, go ahead, Mr. Jaffe.
Thank you, Your Honor. The motion was filed properly served on this individual. Sorry, it was his poor decision to not retain a lawyer because he's not a lawyer and he has no idea what he's doing. That being said, he never filed a response, Your Honor. This is well over a month ago. And not only did he not file a response, Your Honor, but I just want to state for the record, and I have verification, but I don't need to get into it. This might be one of the most disrespectful people I've ever encountered.
Based on, and just get to that. You guys don't have to like each other.
Failure to state a claim, Your Honor. This individual has never presented an iota of evidence to substantiate any claim that he's ever made, but rather this lawsuit was just an attempt for him to defame and harass my client. But again, Your Honor, no response. And respectfully, Your Honor, I would ask that this court hold this person to the same standard that an attorney would be held to. I would ask that my motion be granted accordingly, and this case be dismissed.
Sir, do you have a response?
Yes, Your Honor, I do. First and foremost, I was under the impression that defense never bothered to file an answer to this case to begin with. Moreover, as defense is trying to claim, my attorney was never present during the said case, the previous custody case between defendant and myself. I have been.
So let me ask you this. Let me ask some questions. The parties were you married or dating?
Dating.
All right, so how long, when did you start dating?
We were together 5 years.
When did you start dating?
2018.
When did you split up?
22.
Okay, so you split up in 22. Your allegation is that this,
If I may, Your Honor, we started in 17, not 18. Our daughter was born in 18.
Okay. So basically the allegation is that.
This is classic courtroom tension. The plaintiff claims he's owed $6,500 for what he calls microtransactions, even while his ex was the primary caregiver for their child. Judge Shackelford and Mr. Jaffe immediately start calling out the logic, or lack thereof. This is where reality hits. Raising a child isn't a business transaction, it's a responsibility. Trying to convert co-parenting into a financial ledger is a fast track to losing credibility in court. Look at the way the judge peels back each claim. She's not here to play referee on grudges. She's here to apply the law. Audience, what would you have done in his shoes? Would you pursue money for shared expenses or chalk it up to life lessons?
a bunch of these miniature charges were made. At the time, where you two lit these charges for like $3, $2, $1. I don't know if these are all like phone games.
That's exactly what it was.
Okay, it looked like phone games to me.
Microtransactions through mobile
So
phone.
these were all charged, at the time the two of you were you living together?
Yes, Your Honor.
All right, so you were living together, you were cohabitating.
Yes, Your
Who
Honor.
was working?
I was.
Okay, and Miss Davidson did child, so is it a baby at this time or a young kid? I mean, there's no year on IFC like 1106, 1217, 320. It didn't tell me the year these charges were made. Like, I can't tell from looking at the documents that were submitted when they were made. It just says year, or it says month and day.
That is fair, Your Honor, and I do have a stack of papers more than an inch thick of 4 years of bank records. I would be more than happy to bring to.
Were you guys living together at that
Yes, Your
time?
Honor.
Okay,
But the record
so,
also showed that she emptied my checking account while I was providing for both her and a minor child. One of those instances occurred while I was at a grocery store with a shopping cart full of stuff, and she still emptied my checking account.
all right, but there's no claim for that in here. I mean, I just see the claim is that I don't mean to call them micro
That's
transactions.
exactly what they are.
But they're like $1.05, $1.05, $4.69, 91 cents, $1.05.
Several hundred in total.
These are, well, then what is you made a claim for 6,500.
Yes,
What is-
Your Honor, and if I may also point out that during the custody agreement, when we were ordered by the
Now we hit the meat of it, the law versus emotion. Michigan Rule 2.116. C8, basically the state's version of Federal Rule 12b6, is in play here. It's all about whether a lawsuit states a legally valid claim. And here's the kicker. The plaintiff's accusations, from supposed credit fraud to emotional distress, are largely unsupported. Judge Shackelford is clear-eyed. If your claim has no legal foundation, it's gone. And notice her tone. It's firm, measured, but not cruel. This is a lesson for anyone thinking that emotion alone can win in court. Who here thought $6,500 for phone games and parenting favors would stand up in court? Reality check.
court, week on, week off custody on a dozen separate occasions. I have made verbal agreement, which I'll quote Pennzoil v. Texaco, and that verbal agreements are enforceable. I made a verbal agreement with defendant to take child on defendant's court-ordered scheduled week so that she could go out with friends in exchange for her to do the same on my week, and I was robbed of that a dozen times.
Important to me. I have $6,500 of claim damages for a bunch of microtransactions that equal hundreds of dollars. And those transactions all occurred during the course of your cohabitation while you were the primary caregiver.
Yeah, Your Honor,
Wow.
that is correct, Your Honor. That is correct, Your Honor. And again, just to reemphasize that, again, not an iota of information or supporting documents or people with Texaco, whatever the legal scholar is quoting, has ever been presented to me, nor has this person ever contacted me. Again, he was rightfully served, Your Honor.
Well, it doesn't matter. I mean, if they're talking about making agreements outside of their parenting time order and one party's honoring them and the other party isn't, I am a district court judge. I do not do family law. I am not going to overstep my bounds and get involved in that. And certainly, I'm going to tell you my honest thoughts. I did family law for a long time. And if you two can't figure out how to get along on some level, you're going to screw your kid up. I'm just telling you, that's how it is. That's what I see here. And I see it all the time. And it's really disturbing to me because if you two talk poorly about each other, get mad at each other, in front of the child, can't communicate with each other, you are messing a kid up. You are. And I mean, and that's a family law matter. It's not in front of me, but
And Your Honor, I did
I'm
represent.
very sad to see it over and over and over again. Sir, do you have any other documentation that you want me to look at?
Your Honor, if I could actually go back to the motion in which defense made an effort to claim that my counsel never appeared.
Why do
This section highlights something a lot of people miss. Co-parenting conflicts often end up tangled in the law when parties fail to communicate. The plaintiff claims he was deprived of parenting time, But Judge Shackelford is pointing out the real problem. You can't turn every domestic disagreement into a lawsuit. And let's talk about irony. While he's accusing her of defrauding him, the math suggests he benefited from a year of unpaid labor and childcare. Courtrooms aren't here to settle emotional scores. They're here to apply the law to provable claims. And this is where the audience can really learn. Emotional reasoning doesn't override evidence in court.
No, he's saying, no. Listen, he is trying to get your case thrown out by saying there's no relief and there's no claim, that there's no legal basis for your claim.
So.
Is that you failed to state a claim on which relief can be granted. So I keep asking you, what matters to me is what documentation do you have that she owes you $6,500?
Your Honor, would a couple write a contract for who's going to pick up children from school any given day of the week? No, most couples are not. So in the same sense, if a couple is together and one party owes the other money, are they going to write a contract?
Yeah, the answer is
No, and when one of the so are you charging her for food she ate while she was the primary caregiver for your child and you were at work? Is she have to pay you back for the food she ate?
I'm asking
you a question, and guess what? I got the robe, sir. So I'm asking you a question. Does she owe you money for food, shelter, clothing that you paid for her while she was the primary caregiver for your child?
Your Honor, she does owe me for food, clothing, and shelter during the 10 months.
This is one of those jaw-dropping moments. The plaintiff is claiming defrauding by solicitation of prostitution. But Judge Shackelford and the commentary here make it clear. This isn't fraud. It's a misunderstanding of legal definitions mashed with personal bitterness. When the facts are checked, it's obvious who owes what, if anyone. And the audience can't help but marvel at the disconnect between personal perception and legal reality. Keep your eyes on how the judge dismantles this claim, because it's not just about this case. It's a masterclass in separating emotion from enforceable legal rights. Have you ever seen someone misinterpret the law this badly?
All right, listen. The request for relief in this case was the maximum that was allowed in district court in small claims. It's since been removed, but the amount claimed was $6,500. And the allegations were credit fraud, defrauding by means of solicitation of prostitution, possession of stolen property, promissory fraud, and emotion.
I do have several hundred hours of audio recordings held within my own home, as the Exhibit A submitted by the defense shows that the defendant was made aware that everything in my home was being recorded.
Your Honor, may I address the court briefly, Your Honor?
Very brief.
Thank you very much, Your Honor. As a practical matter, I represented my client also in the custody matter for like over the period of like almost a year. And respectfully, Your Honor, I'm not sure why this plaintiff feels he has a platform to do it. Your Honor, again, there's no relief has been, nothing's been substantiated, Your Honor, and they actually took this serious, which I don't think he is. And again, I think it's a pure harassment technique. And he would have hired a lawyer, because that's why people pay a lot of money to go to law school.
All right. I mean, listen, Mr. Jaffe, we don't have to get in the mud though. Like, listen, as far as I'm concerned, I don't see any claim that relief could be granted on. I mean, all of these, when you have two people and look at, I'm going to just use common sense and reason. When you have two people who are cohabitating with a minor child, an infant, or a very young child, what year was the child born in? 2018?
February 2018.
So we're talking about a kid who is not school age,
Correct.
right?
She's 5 now and in kindergarten.
She's 5 now, but all of these purchases, all of these, what I'm calling microtransactions, all occurred while the two of you were in a relationship, while she was the primary caregiver. And there are agreements that are made. I mean, you can look at it with common sense and reason, which is what I'm doing. And we're talking like, look, she likes phone games a little too much. I'll give you that, but you can't come a year and some after the parties split up and claimed $6,500 in an action because of transactions that occurred. She clearly had access to money. Did your client go to the grocery store, Mr. Jaff?
Here's where documentation, or the lack of it, becomes the star. The plaintiff talks about hundreds of hours of audio recordings, but Judge Shackelford and counsel make it clear. Having raw material doesn't equal a legal claim. Evidence must support a specific legal argument, and here, the narrative falls flat. Watch how logic hits emotion. This is the courtroom reality check. And this is a good reminder for the audience. Keep your evidence organized, factual, and legally relevant. Otherwise, even a mountain of material can collapse under scrutiny. How often do you think disputes like this get thrown out because the evidence is chaotic or irrelevant?
Of course, for the family, of course.
At the time, no, Your Honor, she did not. She did not
Your
have a
Honor,
license or-
absolutely. And again, Your Honor,
Wait,
yes, yes.
I have a court recorder. Do not make her suffer. She cannot type both of you at the same time. Okay, so you're telling me, Mr. Van Maren, that she did not ever have access to any bank account?
She had unlawful access to mine when she saved my credit information in her phone without my permission.
Okay, wait. So the whole time you were
My
together,
grandfather took me shopping.
so she was never allowed to go to the store or make any purchases?
She went with me.
No access to money. It's your statement. This is what you're telling me. She had no access to any money at all while she was staying home with this minor
She
child.
couldn't be trusted with money, obviously.
Okay, all right. I find that there is absolutely the plaintiff has failed to state a claim on which relief can be granted. We're talking about microtransactions that occurred during the relationship between the parties where they resided together and had a minor child, and Ms. Davidson was the primary caregiver for said minor child.
Your Honor,
Obviously, sir. If you want to file an appeal, sir, you are certainly entitled to that relief. That is my judgment, Mr. Jaffe.
To wrap up, this case is a prime example of what happens when personal resentment masquerades as legal action. Judge Shackelford applied the law consistently, dismissed claims lacking legal foundation, and reinforced the importance of evidence over emotion. It's a masterclass in judicial efficiency and legal clarity. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Keep watching, because the next case could be even more dramatic, and the lessons even more eye-opening.